Ms. Peoples, can you hear me? Please unmute. There you go.
Yes, Your Honor.
All right, good afternoon, everybody. My name is John Delaney. You're aware that I was assigned to preside over your case from this point forward. And we're scheduled today for what I call a scheduling hearing or status conference, if you will. It wasn't my intent to go into any substantive matters today or make any rulings about procedural disputes or substantive law disputes, but if both sides are in agreement about taking up anything of concern to you today, I'm happy to make myself available. I promise you that my intention here is to be as accessible to both sides as possible to try to get the dispute litigated to a trial court conclusion at least. So with that said, petitioner, Ms. Telegina, do I pronounce it?
Exactly, Honor. That's correct. My name is Tatiana Telegina.
Very well. I wasn't sure whether it was Telegina or Telegina.
Telegina. It's quite
Very
right.
well. And I don't see another party here, but on behalf of the respondent is Ms. Peoples. Are you the lead counsel today?
I am the attorney of record, Your Honor, but Mr. Wilson is going to be taking the lead today
Very
during the
well.
status conference.
Good afternoon, Your Honor.
Good afternoon. Are you ready as well, Mr. Wilson?
Yes, Judge.
Okay. You notice we have the court administrator, Linda Newland, on the hearing with us. We don't have a court reporter present. Is that consistent with everybody's wishes for today?
I think so, Judge. I think that we should, as you stated at the outset, focus on kind of scheduling and status issues rather than diving into any of the substantive issues or merits of the case.
So let me observe. Thank you for that. Ms. Telegina, are you okay for today proceeding without a court reporter?
I'm fine, Judge. Thank you.
Very good. You are probably both aware that we are making a recording in the Zoom technology right now. So on request, I'll be happy to provide a link to anybody who wishes it.
Actually, Judge, I'm not sure, but I see that we are live on YouTube. But I may be wrong. That's what the system is showing me.
Yes, that's correct.
Okay.
But we're also making the live Zoom recording as well.
Okay.
The only reason you're live on YouTube is because it's generally thought during this Zoom period that to comply with the open courts provision of our state constitution, that this is next best thing. So perhaps you're curious about me. Perhaps you've done what research you can online. I don't know. You don't have to confess to it. If you have, that's okay. Let me give you the short story. First of all, I'm located in a place called Bryan, Texas, which is adjacent to College Station, Texas. They share a border. And it's the location of Texas A&M University, the largest state university in the state of Texas, as it turns out, which is about 67 miles from Conroe and 90 or 100 miles from Houston, if counsel is located in Houston. The only one I'm confident is in Conroe, I think, is Linda Newland, but maybe that's not even true.
I'm in the Woodlands, Judge. I'm much closer to you.
Ah, well,
Yep.
you have distinct advantage in the litigation then. If you,
Absolutely.
I am what's called a senior district judge, which means nothing more than I worked long enough as an elected district court judge to earn retirement. And then upon retirement in the year 2000, I made an election to continue to be available to serve by assignment. So in exchange for that, they bestow on me the title of senior district judge. Incidentally, you may be hearing some background noises. That's explained by the fact that some solar panels are being installed on the roof of my house as we speak. So we may be interrupted with a little bang, bang, buzz, buzz. If it gets to be a problem for you, the guys have promised me they would shut down and go away for today. So as a trial court judge, I spent close to 20 years working as what we call a general jurisdiction judge, which means that I handled a docket of both family and civil and criminal cases. And this was before the era of court masters and the like. So I tried my own temporary orders hearings, as well as the trial on the merits. I've handled 5 capital murder cases. I've presided over something north of 575 jury trials. And I have no way to count the number of bench trials. Since retirement at the end of 2000, I've served as a mediator in private practice. I do that to this day. Got a big file cabinet full of mediated settlement agreements over here to my left, while also serving as a visiting judge. The first few years after retiring, I spent a lot of time going to Conroe. There was a district court judge there who was himself retiring, and he asked me to fill in for him quite often. So that's how I happen to know it's 67 miles to the courthouse in Conroe. I continue to travel to Conroe off and on, so I'm familiar with the place. Our regional presiding judge has his offices right across the street from the courthouse to the west, and so I'm a frequent visitor there. So in retirement, in addition to mediating cases, I guess my principal occupation has been as a visiting judge, and more specifically in child welfare cases. For the last 10 years, I've handled all of the child welfare litigation in 3 counties, and I left that behind at the end of December because of some state reorganization that was happening. So now I'm back in the free market of being a have gavel, will travel kind of senior judge. So I handle all kind of cases. I'm assigned on several there in Conroe at the moment. Okay, so with that said, does anyone have any questions? I'm open to questions about any of that. I'm fairly informal about that.
No, I'm good, Judge. Thank you.
Not at this time, Judge.
Okay, maybe later.
But we appreciate we appreciate hearing the background.
Right, I thought you would, and that's my sole purpose. I should tell you that the court administrator made it known to me that the respondent here, Mr. Nechuk, had filed a memorandum regarding status of case proceedings around 11:46 a.m. She forwarded it to me by email. I've been trying to digest it. It seems to be a summary of what's happened procedurally up to this point, although I haven't finished reading it. I appreciate that. And I would now like to turn to the issue of where we go from here. And petitioner, you can go first since you're a petitioner, and then I'll hear from respondent, and then we'll have a dialogue about what I need to decide today.
Thank you, Judge. I would probably need 5 to 7 minutes.
You're more than
And-
welcome. Take all the time you need.
Yeah, okay, thank you. I will try to be brief. It is not, first of all, I would like to apologize for my English, for my accent. That is not my choice to be represented pro se in this litigation. But this is a divorce dispute. This is a division of marital property dispute. And my legal position is that all our undivided marital property was confiscated from me by my husband. And I simply have no money to hire an attorney. So once again, I apologize for my accent. If there will be anything at all that is not clear what I'm saying, feel free to stop me anytime and clarify the point. I don't mind. I will not feel bad about that. So that's what I wanted to say. As you mentioned, 2 hours ago, respondent filed a memorandum regarding status of case proceeding. Apparently, my opponents are trying to create a negative impression. At least that's how I feel about this paper.
Let me interrupt you right. Hang on, just let me interrupt you right there.
Yeah.
And then I'll allow you to proceed. First of all, there's no difficulty at all with your accent.
Thank you.
It's not a barrier to communication at all. So certainly no apologies are needed. Secondly, I don't want us to feel any necessity to defend or promote some position taken in this memorandum. I'm always fearful that parties will think it is useful to cast aspersions on the other side unnecessarily. But I at the same time, I recognize that when lawyers are representing clients with zeal, they feel an obligation and a compulsion to advocate, okay? But I will tell you both that as a trial judge with many miles under my belt, I don't really appreciate an obvious attempt to prejudice the other side with irrelevant material, okay? When I was a young judge, I adopted the phrase, don't let this descend into a good guy, bad guy contest. There may be a clear good guy and a clear bad guy. I don't care. We're not going to waste our energy having a contest over that. We're going to stick to the facts and the law. So with that said, please don't feel any necessity. Well, first of all, don't feel that you have been biased in any way, that I have been biased in any way by anything said in this status report. Don't feel the compulsion to defend yourself and file a competing paper unless it's really, really, really necessary. So with that said, go on.
Thank you, Judge. Actually, I was trying to lay the foundation of me filing a competitive paper. So you're quite right about that. I believe it is necessary, and I will try to have this paper brief, 1-2 pages, and I will be filing it by the end of the day tomorrow. It is necessary because the paper that you have in front of you is a little bit one-sided, to say the least.
I would be shocked if it weren't.
Yeah, so it will be only fair if I will file a paper that will show to you my side of the story. Again, very briefly.
You understand that when you file that, the other side is going to feel offended in the one-sided approach you have taken, and they're going to feel a compulsion to reply to it. But do as you like.
Judge, I think that I believe it's proper for you to see both sides of the same coin. And I don't think we will go into the 4th, 5th, and 6th side. I think we will stop at this point, like one side and another side. And we will stop there, hopefully.
That's fine. We've settled that.
Okay. The reason why I believe it is important to me to file a follow-up paper, because this memo actually doesn't provide any information about status of this case. For example, it doesn't mention any pending motions, and there are some pending motions, and I will be bringing these motions to your attention today. These are motions that were filed beginning of October. They were set for the hearing and canceled because of Judge McDonald's recusal. So it's something that you inherited, and these are important motions. But let me first tell you what yes, sir. I thought you asked me to stop. No?
I did.
Okay, so I
was asking if you all could hear the grinding sound.
No,
Very briefly.
It's right outside my window. It's about 8 feet away.
Let them
One single buzz.
It's not disturbing at all.
It's gone now. I may have to ask you to stop because it was very loud for me, but it's not a problem now. Proceed.
Okay. So I think we all spent a sleepless election night tonight. And I think that we're all thinking a little bit politics even now. So there will be no better time to say that I believe that this case is not so much about divorce and not so much about undivided marital property. I believe, Judge, that this case is about politics. And the major question of this litigation is what law should rule in Texas? Russian law or Texas law? And this question is yet to be answered. And that's why I'm bringing this question to your attention. 2 years ago, my opponents, and there are actually 2 law firms working on this case. Only one you see here today, but there are 2 law firms. And these are very competent attorneys and competent lawyers. And I think there are at least a dozen of lawyers and paralegals working on this case. So somehow my opponents managed to convince this court 2 years ago that Russian law should rule in Texas. 2 years ago, this court issued an order stating that my husband and myself, we are divorced in Texas under Russian law.
I am familiar with it.
Yes. I was not aware how deeply you are involved in with the knowledge of this case.
I should have told you both at the beginning that
Yeah.
I've been favored with a procedural summary of the case given to me by Judge McDonald. Very brief, but hitting the high points about the procedural history. And I assure you that Judge McDonald, for whom I have the highest respect, did not attempt to influence me for or against either party, simply summarized the procedural history of the case and the rulings that she had made. I'm sure there's some details that I'm not aware of, but you should know that I'm aware of that ruling.
Okay. So, Judge, you know, now I know that you are aware of the major disagreement that we had with this court. I mean, myself and this court. I believe that this piece of paper, which is a divorce certificate that states it is issued in Houston, which was enforced 2 years ago with this court, who granted comity to this piece of paper, which is, to my legal opinion, is nonsense, because this paper states Houston as place of issuance. It was issued in the office building in Houston by Russian government clerks, and by no means it could be considered as a foreign judgment. This paper is not even properly authenticated, but I will not spend your time on this now. So I believe my legal position is that we are still married, but Judge McDonald disagreed with me and 2 years ago enforced this paper and declared that we are divorced. Since then, my opponents filed, requested Judge McDonald to dismiss this case at least a dozen of times. Only this year, they filed 6 motions asking, yes, sir.
Go on.
I just wanted to say that there are things that Judge McDonald disagree with me with regards to this enforcement of this paper, but she agreed with me that we have other claims, that I have other viable claims that need to be determined. And that's why this case was not dismissed so far. We are still here despite a dozen of motions to dismissal. So I believe this divorce certificate that was issued in Houston by Russian government clerks violates Texas public policy, Texas family law, federal government regulations on many dimensions, and Russia is not just another country, it's US biggest global political opponent. So it is a country that is under US sanctions since 2012, when the group of Russian spies were arrested here in Houston by FBI. And I think that something is wrong, Judge, that Russian law was overruled in Texas on its own soil. So that is, I'm done with briefly summarizing my legal position on this case. So what I actually wanted to request now is to bring to your attention that there are 3 motions that you inherited in these litigations. All 3 motions were filed at a certain point of time. They were set for the hearing, and then the hearing were canceled. I don't know how you want to proceed. I can now list this motion and explain why they're important, because Miss Linder told me that she cannot set these motions for the hearing. and that should be determined today. So that's one thing that I'm expecting today from this status conference.
Okay. I would like for you to list the motions, not necessarily by their precise formal name, but as much of that as you'd like to give me. And rather than argue the substance of the motion, just tell me why procedurally, by summary, why you think it should be heard first, and then second and third, or should they all be grouped together at one time for one hearing? Things of that nature, okay? But let's try to avoid going to the substance of the motions. I'm
not even ready to do so, Judge, today. So yes, I will just listing the motion. I will go from the motion for contempt that was filed on July 23rd. The Judge McDonald issued a show cause order, and the motion was set for the hearing on October 26th, which was the day we were supposed to have a trial.
The jury trial.
Jury trial, exactly. It was actually a pre-trial day. The jury was supposed to be to start next day on October 27th.
Okay.
So I will be, I just bring this motion to your attention, but to follow the procedure, I will be now filing a motion asking you to issue another show cause order with a different date. I'm just explaining I just bringing this motion to your attention. I'm not asking you to rule on this motion. I'm explaining that by the end of the week, you will be getting a request to issue another show cause order on this motion. It will be, I think, 1 page, 2 page length. Another motion is a motion for partial summary judgment. This motion was filed on October 5th and set for the hearing on submission on October 26th. The hearing was canceled for the same reason. That is an important summary judgment motion. It is super lengthy, Judge. It is, I think, 25 pages. In this motion, I'm requesting a judicial determination that 2 marital agreements that are in dispute in this litigation are ambiguous. We have 2 marital agreements that respondent is trying to enforce in this litigation. They are ambiguous. Judge McDonald agreed with me back on January 27th when 2 motions for summary judgment, 2 respondents' motions for summary judgment were under her consideration. But unfortunately, she never issued an order clearly stating that these 2 agreements are ambiguous. She simply denied 2 respondents' motions for summary judgment and agreed with me that this matter should be resolved by fact finders. But I believe that to properly follow the procedure, I need judicial determination from the court that these agreements are ambiguous, so we could probably supply juries with the proper jury issues, because I will be asking the jury to reserve the ambiguity of both agreements. And that is the reason why the motion is lengthy, because I go line by line and explain to you why each agreement is ambiguous. Again, the motion was filed on October 5th, and it was set for the hearing and submission for October 26th. Respondent never filed any response. Maybe they will be doing it now, but no response was filed. And the last motion that I would like to bring to your attention is motion for reconsideration of the court's order of September 2nd. On September 2nd, this court struck 9 causes of actions from my pleading. And all facts, literally all facts that are justifying my claims. This order was issued pursuant to the special exceptions filed by respondent and motions to dismiss. Motion to dismiss was denied, special exceptions were granted with this order. I believe that special exceptions are defective for numerous reasons, and that's why I filed this motion asking the court to reconsider its order. I believe, Judge, that probably it will help if you start from this motion, because you will form your own opinion on my pleading. Whether my claims and causes of actions are defective, if they're cognizable or not, at least you will form your own opinion with which claims and which causes of actions we are proceeding for trial. For me, this motion is probably most important from all 3. And again, it was filed on October 9th, 2020. It is even more lengthy, but only because it cannot be short and sweet I cannot make it short and sweet because I had to go line by line through every special exception and through the court order. And as I said, the court order struck 9 causes of actions in their entirety. And I believe these causes of actions are cognizable causes of actions. They're well justified, and we should proceed to trial with them as well.
Okay, a question about this particular motion. You're asking the court to reconsider the order of a certain date. And what is that date? September
2nd.
September 2nd?
September 2nd. The order is, the long title of the order is Order on Respondent Special Exception to Petitioner's 6th amended petition, motion to strike, and motion to dismiss. The order was rendered on September 2nd, and I'm asking the court to have another look at this order.
And the motion that you're referring to, you said was filed October when?
October 9th.
2020.
Exactly.
And the original order was September 2nd of 20 or 19?
2020. It's a very fresh order, very recent order. Yes, Judge. And so for the moment, this is it. And I will probably, I actually was preparing a couple of more motions, but I put them on hold because I wanted to have our meeting today to hear back from you and also to clarify what is the procedure, because normally I would, after filing a motion, I would apply to Ms. Linder, to the court administrator, and ask her to set my motion for the hearing, and same would do my opponents. And the question is, how would we proceed now? That was my question.
in your opinion, would it be best to set the third motion that you referred to first as a standalone motion?
I
Or-
believe that, I believe that that's probably the best solution, because this motion, my third motion, is about my pleading. If you go through this motion, which is, I don't know, it probably take you several days to go through it, but at least you will get absolutely clear picture of what are my claims, whether some of my causes of actions, because there are 17 causes of actions.
Okay, I think you've answered my question.
Yeah, yeah.
So to be clear, your position is that for judicial economy, it would be best to get this motion considered first by itself and then go from there.
Yes, Judge.
All right, are we at a stopping place for you then? For me to allow me to hear from the other side? I'm asking if you were at a stopping place with your presentation so that I can now hear from the other side.
Oh, yes, Judge, certainly. I'm sorry, I didn't get it.
All right, Mr. Wilson.
Thank you, Judge. I'll just briefly first touch on the brief or the memo that we filed earlier today. Really, the goal there was to provide a procedural history with dates and events during the case. We weren't sure if you were going to receive that from Judge McDonald, so we wanted to at least provide something that was able to help in your review of the case file, which I know is a large case file. So we wanted to try to break it down into procedurally what some of the more meaningful events are that have happened so far since the case has been filed. And a few of the exhibits that were attached to that memo, Judge, are a few of the orders of Judge McDonald that I would say have more of an effect on what's remaining, the issues remaining, and eventually what's going to be tried at our trial. Really, the case started as a divorce case, but it now is mostly a contracts case with two contracts in question, a prenuptial agreement and a postnuptial agreement. Our position, Judge, and what we had expectations for today is to determine kind of where exactly we are and how we continue with the next step. Judge, we want to the extent that we can, avoid relitigating issues that have already been decided by Judge McDonald. The case has been on file for just about 3 years now, and we were scheduled for our jury trial to begin last month, October 26th. So we would like to discuss how quickly and logistically how we're going to be able to have another jury trial scheduled, and logistically what that would look like. I know that you are in Bryan, and I don't know what the available visiting courtroom situation is like in Montgomery County. I know the current COVID situation has made jury trials in particular difficult. In our case, in particular, Judge McDonald received the blessing from the Office of the Court Administration and of the regional presiding judge to go forward with her jury trial plan that was put together specifically for this case. And we were scheduled to get that started. And really, Judge, that's where we would like to pick back up with getting a trial date selected, scheduled. I know these outstanding motions. I'm happy to walk through these, and maybe we can select some dates that for the motions that Ms. Telegina had mentioned too. And hopefully we can get a trial date, an agreeable trial date selected today, so we can continue moving this case toward a final resolution that's going to have to be obtained through a trial.
Bear with me while I'm just thinking. So, Mr. Wilson, did the respondent side of the case file any response to the motion to reconsider that Ms. Telegina has described to me? I'll call it motion number 3.
If you would give me just a minute here, Judge, I can check. I'm not sure off the top of my head if we did file a response to that motion in particular.
No, Mr. Wilson, you have.
They have not?
Yeah.
The reason I ask that question is that may very well be something that's easily handled by submission as opposed to an oral hearing. I'll consider the position of both of you about that. What do you say to that, Ms. Telegina?
Judge, I'm fine with both solutions. Whatever suits you. I think that it is pretty much technical motion, one line by line, case by case, citation by citation. It's just a very mechanical job that unfortunately I dragged you into because it's 45 pages motion, and that's unfortunately that needs to be done. I don't think that presenting this motion will somehow help you. Normally, I would ask you for an oral hearing to help the court, but that's not the motion for the oral hearing.
So let's think then, do you have any opposition to that, Mr. Wilson?
No, Judge, I would agree that hearing by submission would probably be best for that motion. And I did confirm that we haven't filed a responsive pleading to that. So just in scheduling that for hearing, Judge, I would request that we'd get ample time to respond to what Ms. Telegina has described as a lengthy motion.
Tell me how much is ample time?
Judge, how about by, I think 10 days is the norm for submission. So I would say by November 16th hearing day, which is not next Monday, but the following Monday. I think that would provide ample time to file a responsive pleading.
So I'm going to make an order in a moment about the due date for your responsive pleading. What date would you like? If I have submission on the 16th. Let me guess, 5 p.m. on the Sunday the 15th.
Oh, that would be fine, Judge, or the morning of, or 5 p.m. the day before, I think would be just fine. And in that case, maybe we could set it for that Tuesday, and then we'd have Monday to file it.
So in fairness, we need to give the movement an opportunity to have a reply.
Judge, I will not be doing that, so you can skip that. I think
Very
that
well.
my motion is so detailed that I will not be responding to their response. I think it will not be effective use of your time.
Then I'm happy, Mr. Wilson, to take it under, rule on it by submission. Tuesday the 17th sounds good, because that way, if your response is filed by Friday the 13th, that will give me the weekend to prepare, perhaps, to be able to make the ruling on the 16th. Or did I say the 17th?
17th.
17th then. Submission on the 17th, and you've got to file by close of business on the 13th, Mr. Wilson.
Yes, Judge.
That'll give me enough time to hopefully be prepared and make a ruling on the 17th.
And Judge, if I may ask, in terms of, just because this is kind of a new scenario for all of us here, do you want us to submit our filings as we do through the e-filing system? Do you want a copy emailed to Linda or to you after it's been filed? Just how is the best way for us to handle that, so that we can get it to you?
Hold that question while I record my notes. So I have no difficulty whatsoever in having counsel file and send me a courtesy copy. And if the court coordinator wants something different, I'll let her speak for herself.
I think that's fine, Judge. As long as we have something in the case file that goes through e-file and they send you at that time, maybe copy me on what you send, Judge, only so that I know also to be looking into your case file, because sometimes you file things like your memorandum today. I just happened to open up your case. They hadn't sent it to my queue. So I just happened to see it in time to send it to Judge. So just so
Okay.
I know, that it's been filed.
Thank you.
So that's the plan then.
That works.
You e-file, and then you follow up with an email to the court administrator and myself with the attached material.
Yes, Judge.
And
Judge, if I
that will
may,
be-
I just want to clarify, just to be sure 100%.
hang on.
I'm sorry.
That will be true for both sides throughout the litigation until I change it if I have to.
Okay.
I see no reason to burden the court administrator with the job of forwarding something to me. If it's ultimately going to get to me anyhow, then why delay it at her desk? She might be ill. She might be on vacation. The essence of bureaucracy is having a paper go from desk to desk to desk to desk. So we just cut through that by having it go directly to me and her both. Now, Ms. Telegina.
Judge, apologize for interrupting. I didn't mean that. I just wanted to be sure that the motion that you titled motion number 3, motion for reconsideration, is set for the hearing on submission for November 17th, 5 p.m. Is that right? Okay. Mr. Wilson, do you need a notice on that, or you will take it from this hearing?
We don't need any filed notice. We'll be filing our response by Friday at 5. Friday, the 13th of November by 5. Thank you, though.
Judge, I also wanted to remind you about the motion number 2, a motion for partial summary judgment.
Yes, I've been studying that and thinking about it. You know, to the extent that we appear to be headed toward a jury trial, it's usually beneficial to get some required determination out of the way if it can be ruled on by a summary judgment, partial summary judgment. This was filed on October 5th. Well, was there a response by respondent?
No.
No, Judge.
So how do either of you feel about me setting a submission for that?
Same, Judge. It is also a very technical motion. It has a number of cases cited. I explain why I believe the summary judgment is necessary. I'm not asking you to resolve the ambiguity of our contracts. I'm asking you just to determine that these contracts are ambiguous. This is it. It's also a very technical thing. You just have to go through my motion and contracts and agree or disagree with me. And depending on your decision, I will be preparing a jury charge for the juries, because if you agree with me, and actually it was Judge McDonald who agreed with me but never issued an order, a specific order that these contracts are ambiguous. So if you agree with that, then jury have to resolve this ambiguity. Yeah, that's the logic behind this motion. I don't need oral hearing on this unless my opponents would request oral hearing. I'm fine with the submission.
So let's pause a minute and open another page here. I think you represented to me that, Ms. Telegina, I think you represented to me that the respondent had earlier filed a motion for partial summary judgment that you defended on the ground that the marital property agreements are ambiguous. Is that correct?
Are actually 1.5 years ago, respondent filed 2 motions for summary judgment, traditional and no evidence. Both motions were taken by Judge McDonald on January 27th this year, and we had a very lengthy oral hearing on these 2 motions. These 2 motions were not motions on partial summary judgment. Mr. Wilson may be better suited to present this, to brief you about these 2 motions, but there were general summary judgment motions asking to dismiss the case briefly, that to ask the court that we are all settled. Not settled, but there is nothing to left for the court to determine. When I was defending these motions, I was able to convince Judge McDonald that there are
County Court 3.
fact issues that need to be determined by fact finders. And she agreed with me. And that's why both motions were denied.
Bob, would you please write me?
And part of my arguments were that both marital agreements are ambiguous. So it was part of my defense. Judge McDonald denied both motions, but actually never issued any order explaining why she denied or specifically determining that these agreements are ambiguous. And my legal position is that before asking jury to determine and resolving the ambiguity of these two agreements, I need this court to determine, to render judicial determination that these agreements are ambiguous. And in what way?
All right, Mr. Wilson, what are your thoughts about A, whether you want to make a response, and B, when, and when you think it's reasonable to have me rule on this by submission? I
Judge, we would.
don't rule out the possibility of taking them up at the same time to lessen the complication.
Judge, I think hearing this summary judgment motion by submission would be best as well. I agree with that. I would like a longer opportunity to be able to file a response to the summary judgment motion, Judge, and would request that we set that with the 21 days out notice, and we can file our response 7 days before that. The usual timetable for motions for summary judgment.
But you were already given that, weren't you? For the October 26th date?
That's very true, Judge. The notice was part of the motion itself. Oh, I'm sorry. Yeah, I will.
Judge, we received the motion that was filed by Ms. Telegina, and we were informed that the motion was not docketed and was not set for hearing, that Ms. Telegina had included a date in her notice of hearing at the time that she filed the motion, but that it was not approved and actually docketed and set for hearing. So with that in mind, the October 26th date that Ms. Telegina is describing, it was not actually set that day. We did not prepare and file a response for the reason that it wasn't docketed and scheduled to be heard.
So I'm really not sure about, well, I've been told the content has to do with ambiguity. I don't know what summary judgment evidence you would marshal to defend that. I mean, it's a legal question about whether it is or isn't.
Surely.
Why would you need full 21 days?
Your Honor, I was just trying to keep the scheduling in line with the procedures for filing motions for summary judgment. If you're inclined to take it earlier, then yes, it is primarily a legal argument, and I can work on getting something done sooner. My concern on hearing them both on the same day would be only having a week to prepare responses to two significantly lengthy motions.
All right, so what if, I'll just throw something out for consideration. What if we made it submissible 1 week later, on Tuesday of the following week?
And then, Your Honor, my response would be scheduled to be filed by close of business the preceding Friday as well.
Conceivably. The question here is that enough time for you? If you work nights and weekends?
Yeah, I think that would be enough time, Judge. I just want to be sure that my response deadline would be not a week before that, because then I would still be having to file them both at the same time. So I don't know if Ms. Telegina intends to file a reply to
Maybe,
that
maybe.
motion.
Okay, let me hit the pause button here a moment. You know, given the season that we're approaching very rapidly, Thanksgiving and Christmas, I don't feel that we are under compulsion to rush or to put anybody under the gun to get this motion for partial summary judgment resolved. I haven't given up, and I'm still mindful of the desire to get a trial set today. But I'm thinking it's going to be far enough out that I could give you 2 weeks after November 17th to get this done, and nobody would be harmed. Those are just random thoughts.
I'm sorry, Judge, if you were continuing.
No, I'm happy to hear your response to that, and I'll let Ms. Telegina, of course, have her say.
I would
Judge,
appreciate that, Judge, and my thinking too, just as far as where we are, the time of year, some of the logistical hurdles that I mentioned earlier, as far as getting a jury trial scheduled on a realistic timeline. I too, coming into today's status conference, was evaluating the calendar and having serious doubts that we would be able to have it scheduled by the end of the year.
Yeah.
Yes.
Okay, so Ms. Telegina, how do you feel about the idea of having a submission date for your motion for partial summary judgment approximately 2 weeks after the 17th of November?
Judge, when I filed the motion, 21 days notice was part of the motion. So respondent received 21 days notice. They never responded. Are they asking more time to respond to this motion, which is quite simple motion, like, are contracts ambiguous or not ambiguous? I mean, it's very simple, because we all know they are, and we actually never disputed this.
Well, your motion is 25 pages long, right?
That's true, but because I go line by line with regards to 2 agreements. We've been there. That's the only point I'm making. It's your call, it's your decision. I'm fine, but I may be needed to file a response in this case. I'm not sure about it, but I may be needed to file a response.
Okay, let's take this up one step at a time, I suppose. Mr. Wilson, what day would you like to have your response due by?
Judge, I would say the 24th of November.
As a child, I remember my dad, a veteran of World War II, at meal times would often say, that when he was going through Army boot camp, there was a sign in the cafeteria or the mess that said, "Take all you want, but eat all you take." Translation: if you commit to November 24th, make sure you get it done.
Yes,
Okay.
Judge.
Thank you for humoring me there. Okay, then, given that his response is due by the 24th, and we don't know whether he's going to file it at 5 p.m. that day, although he probably will, knowing how the practice of law is. When would you like, how much time would you like to file your reply?
Judge, I will work through Thanksgiving and file it by 5 p.m. on Friday, November 27th.
I would not require you to do that.
It's okay. I volunteer, so it's okay.
Your response is going to be due by Monday, November 30th.
Thank you, Judge.
I'm saving you from yourself. Okay. Given these dates that we've established, submission. I suppose none of you care since your work's done and it's all up to me, right? I'm going to say Wednesday, December 2. Thankfully, however, judges are not always required to eat all they take. I will get you a ruling as fast as I can. Let's take about a three-minute break while I turn on the ceiling fan here and make my room a little bit cooler, and everybody else can make a bathroom break, whatever you wish. 3 minutes.
Thank you.
Okay, we all appear to be back. Shall we move on to trying to consider a jury trial date at this point? We haven't talked about the motion for contempt, but for some reason I got the impression that, well, I don't want to say that. How do you feel about that, Ms. Telegina? Do you want a hearing on the motion for contempt in addition to the jury trial setting? What's your position?
Judge, actually, I think that it will benefit everyone because respondent is now in Russia and he has been, according to his attorneys, he will be in Russia. So I was trying to optimize the logistics. And that's why the hearing of this motion was set for the day before trial. And it's fine with me if it stays this way. The day before trial, when you probably will be getting us together for some pretrial motions or other many things that we will need to determine. So one day before trial or Friday before trial is perfectly fine with me. However, as I said, I will be filing by the end of this week a very simple, very short motion, which is actually a request to issue a show cause order. Judge McDonald already, yeah.
Let's talk about that for a moment. Is that a procedural nicety that, what would the show cause order say? Would it command Mr. Netchuk to appear on such and such date?
And show cause why he should not be held in contempt. It's a very, like, Judge McDonald, I will attach to my motion the order that was already signed by Judge McDonald. So it's only about the date.
And I think technically you have to have him served with that.
Yeah. The question is how, but yes, he should be served.
That's going to be a challenge given that he's in Russia.
I have my legal position on that, Judge, and I will reflect my legal position in my motion.
What about this? What if, just for discussion purposes here, Respondents' Counsel, do you feel that A, your client is going to appear and present, well, in person at the jury trial, and B, would you feel comfortable stipulating that he will be present for the hearing on the motion for contempt the day before without the necessity of procedural formalities like a show cause order commanding him to be there?
Judge, I will say that for a jury trial, yes, he is in Russia. Of course, we plan to, and he plans to be present for the jury trial whenever that is scheduled, barring, of course, some uptick in coronavirus concerns and travel restriction. And, you know, maybe that, if something like that comes up, then certainly we'd have to evaluate the trial setting because he does need to be here in person for our jury trial. So we plan to have him there without having specific dates that we're discussing. I can't really represent that he will be here on a certain day or this day. At this point, I couldn't do that.
Fair enough. All right, let's turn to dates then. I'm open for the next 4 or 5 years.
I think we should be able to find a date in that time frame, Your Honor.
Judge, if you allow me, a small joke.
Maybe we should talk to the court administrator about this.
Judge, if you wake me up in the middle of the night and ask if we are ready for the trial, my immediate answer will be no. By no means we are ready for the trial. But I don't mind setting the dates just to try at least to put us in some schedule. And meanwhile, I will try to bring to your attention issues that we need to resolve before proceeding to trial. So,
Okay, would you prefer that we decide what I'm going to do about the motion for reconsideration and the motion for partial summary judgment before we talk about scheduling a jury trial?
absolutely, Judge. At least the motion for reconsideration will give us your opinion with what we are proceeding to trial, with what causes of actions, with what claims.
So, Mr. Wilson, does your side have a problem with that?
I don't think so, Judge. And as I had mentioned earlier, logistically, I see it being very difficult that we do have a trial by the before the end of the year. So what I would request, though, is that we maybe we schedule sometime after those two submission dates somewhat of a return type status or scheduling conference where we can address or at least discuss when we could get our trial setting set and what that might look like as far as impaneling a jury in Montgomery County and of course the availability for us to be able to do so.
So I'm thinking that if we were to schedule a scheduling hearing to discuss the jury trial date shortly after my submission date of December 2nd, that would be a good time for us to evaluate where we are.
And Judge, can I say something about the jury? We will have to go through the same procedure to get a jury trial for this case as we did in the beginning. We've been approved for a jury trial November 16th, December 7th. So because depending on who's going to be applying, we cannot apply for a date with our COVID plan before any earlier than 34 days before the setting we're asking for. You can't go in there now and put in a plan with the administrative judges and the regional judge. It has to be no earlier than 34 days before your setting. Okay.
Okay.
So,
And
January is a possibility. We could go ahead and set our dates a Monday in, let's say, January. We'd also have to be looking at probably, the visiting judge's courtroom, whether that's available, because we were going to use 2 courtrooms to house 12 jurors for any case that we have a 12-man jury. We're going to use our courtroom and the associate judge's ancillary courtroom in order to spread out the jurors in the, without seating them in the jury box, without seating them in a jury room squished together. We are using 2 courtrooms. So we have a lot of logistics to worry about, whether they're available to us.
okay, so I want to try to avoid anything that week, the week of November the 30th, with the submission date being the 2nd. It may take me all of that week before I get you an answer. So what about if we had a scheduling conference similar to the one we're on right now, except on Monday, the 7th of December, or a date that fit as soon as possible after that, to go through things like the logistics that are, what have you, and then try to arrive at a date.
I would prefer other than Monday. That's our jury week. We're having a jury trial starting that Monday. So I would prefer later in the week, maybe not on Monday.
What about Tuesday? That's later in the week.
That's good. That's good. It's the Monday that's the challenge.
Got it. I've been there and done it. All right, what does your calendar look like, Zach Wilson?
Tuesday, December 8th, I can do Miss Peoples. She'll be
I'm
available on
available.
that day, so that will Tuesday, December 8th will work for us.
And what's your side's preference since I'm talking to you? 9 o'clock, 10 o'clock, me? You name your poison.
Oh,
I'm
sure, we can. Yeah, we can start at 9 in the morning.
Okay.
If
Miss
Linda,
Miss
I'm
Telegene,
sorry.
how about that? How about that?
Judge, I would also prefer 9 o'clock in the morning if it's convenient for you.
That's
And
good. We've got it.
also, yeah,
We've
and
got it.
also, Judge, I have one request. If it's possible to have a little bit more time reserved, because I will probably be filing a couple of more motions and asking for oral hearing just to optimize the logistics. I will be asking you to consider putting this motion on this day, just to, yeah.
I will think about it.
Yes, I'm not asking for the response now. I'm just asking to book a little bit more time of everyone's, just in case.
Well, it'll depend on a lot of things, you know, the substance of the motion, how late you file them and all of that.
I understand.
So we are booked then, we are set for, you're not going to get any further setting notice as far as I'm concerned, other than my Zoom invitation
Yes.
for Tuesday, December the 8th at 9 o'clock a.m.
Yes, Judge.
yes, Judge.
Thank you, Your Honor.
So Linda, tell me, you prefer for me to send you these Zoom invitations for you to then have to turn around and forward to these people? Or what if I just send them to everybody, including
That's
you?
fine with me.
It's fine with me.
Just as long as you include me.
Yeah, again, it makes no sense for you to have to turn
That's
around
fine.
and forward it to people.
I have to do lots of Zoom forwarding, so anything that I don't have to do is great.
Exactly. I don't want you to have to put in a claim for overtime. It's okay for me to do it, but if there were such a thing. All right. Zoom to all. So do I send it? I don't know that I have an email address for Zachary Wilson. Do I?
I think
I
you
don't.
do.
I think it's on the pleadings, Judge, but it's simply my
No,
first initial and last name.
no, don't do that. Email it to me.
Okay.
Maybe it's a good idea to task the court administrator with doing that. Can you do that for me?
Yes,
Send me an email with everybody else's email on it.
sure.
All three of them that are on the screen right now.
Mm-hmm.
So again, since it's a planning conference, scheduling conference, I wouldn't think there'd be a need for a court reporter.
Okay. Unless we have motions.
Unless we have motions. That's right. So I have a confession to make to you all. I have, in the middle of my preparation, I had not looked up Rule 308, whatever it is, yeah. And this question has been occurring to me. 308B through F. Is there a procedure for an appeal from a ruling on that?
No. It's
I think-
interlocutory order that is
I
not appealable at this stage.
Okay. I think somebody sought a writ of mandamus, which was refused.
No, it was on, it was on discovery.
Oh, okay. So I'm new to this part of Rule 308. Never had to consider it before. But it sounds like it's the type of thing that is sort of outcome determinative, up or down. And I would have thought that it would be appealable.
At this stage of the litigation, you mean?
Yes. Now, mind you, I have no authority for those comments at all, except
I
Just-
understand, Judge.
my intuition.
I disagree with this order. I'm sitting and patiently waiting to appeal it. Or I will be quite honest with you because I believe we are still married.
Well, if it is an appealable order, then the time for doing that would have long passed, right?
Exactly.
Respondent, do you have any comments to make about that?
Judge, I will confess that it has also been some time since I have looked at that rule. What I remember about it, though, is that it was actually a brand new rule that the Supreme Court may have actually issued during the case. I think that it was at the end of the year of 2017, if I remember correctly, and it established a procedure for evaluating enforcement of different foreign orders. It also has been a while since I have looked at it, but what I do remember was that when we did look at it, it was not only new to us, it was brand new. So
this question, again, I don't have the text of it in front of me. Does it have an effective date and an applicability provision, like applicable to cases filed on or after such and such date?
I think it did, Judge, but I also don't have it right in front of me. But I believe that if the text of the actual rule, which is the actual rule is Texas Rule of Civil Procedure 308B, and I think the title of Judge McDonald's order mistypes the actual rule a little bit where it says B through F. It's actually 308B, and then there, I think subsection F of 308B addresses the procedures for hearings on the under that rule.
Okay, stand by just a moment. Let me get the text of it on the screen here. Unless somebody has a time constraint. So it appears that they adopted the rule in January of 2018. are effective January 1, 2018.
I think it was adopted in September and came in force from January 1st, 2018.
The TRCP that I have says adopted by order of December 28th, 2017, effective January 1, 2018, is the footnote in the TRCP, Texas Rules of Civil Procedure, that I'm looking at.
Judge, I was relying on actually Texas Supreme Court position that interlocutory order doesn't become final until it merged into final judgment. And that's why I didn't appeal it. And until all issues are resolved in this litigation, we don't have a final judgment. So that was my logic behind this.
So the reason I bring this up is because it occurred to me that there may or may not be Rule 3. Let me start that again. Rule 308B may very well be applicable in the current litigation, or there may be some interpretation that says it is not. The divorce case was, the original divorce petition filed in Montgomery County was filed when?
November 17th, 3 years ago.
2017, right?
Yes.
And so the issue about interpretation of the foreign divorce was raised as a defensive matter.
Yes.
Okay, well, without spending any more energy on that, I just raise it as a consideration in case somebody thinks that it applies in this case and requires further exploration. Are we done today?
I'm good, Judge. I don't have any issues remained.
I think so, Judge. Nothing further from us. We've got our dates and marching orders.
Right, eat all you take.
Thank you, Judge.
All right, good day, everyone. Linda, I'm
Thank
signing
you, Your
off.
Honor.
Thank you for your time. Thank you.
Of course, good day.